The wheels of justice turn in the courtroom. They grind slowly. The process is often painstaking, with each step meticulously examined and re-examined. They often grind exceedingly fine, ensuring that every detail is considered, every piece of evidence weighed. This thoroughness is essential for justice to be served. But what happens when the very act of seeking justice threatens to crush those involved? The emotional and psychological toll can be immense, affecting not just the accused, but also the victims, witnesses, and their families. What safeguards exist to protect the vulnerable, the accused, and even the convicted from the glare of public scrutiny? The media's relentless pursuit of a story can sometimes overshadow the need for a fair trial. This is where the concept of name suppression comes in. It's a critical tool in the legal system, designed to protect individuals from undue harm, while ensuring that justice is not compromised. Name suppression is a legal mechanism designed to balance the scales between an individual's right to privacy and the public's right to know. It serves as a buffer, preventing the premature release of information that could prejudice a case. It's a shield against the potential damage of publicity, a tool used to ensure fairness and protect the integrity of the justice system. Without it, the court of public opinion could easily overshadow the court of law. This essay delves into the intricacies of name suppression, exploring its application, implications, and the delicate balancing act it demands. We will examine real-world cases, legal precedents, and the ongoing debate about its necessity and effectiveness in modern society. Imagine this: a person accused of a crime, their name splashed across headlines before they've even stepped foot in court. The potential for prejudice, for their reputation to be tarnished before they've had a chance to defend themselves, is immense. Name suppression exists to prevent this very scenario. It's a legal order that prohibits the publication of any information that could identify a person involved in court proceedings. This could include the individual's name, address, occupation, or any other identifying details. Name suppression recognizes that the right to a fair trial, the presumption of innocence until proven guilty, is paramount. In New Zealand, the legal framework for name suppression is found in Section 200 of the Criminal Procedure Act 2011. This section of the law is a crucial component of the country's judicial system, providing a mechanism to balance the interests of justice with the rights of individuals involved in legal proceedings. It is designed to protect the identities of those who might be unfairly affected by the publicity surrounding a court case, ensuring that their lives are not unduly disrupted or harmed by media exposure. This legislation empowers a judge to suppress the name of a defendant, a witness, or even the victim of a crime if it is deemed necessary. The judge must carefully consider the circumstances of each case, weighing the potential impact on the individuals involved against the public interest in open justice. This power is not exercised lightly and requires a thorough examination of the facts and potential consequences. It underscores the court's commitment to ensuring that justice is not only served, but is seen to be served fairly and without undue influence. The principle of open justice is fundamental to the legal system, but there are instances where transparency must be balanced with the need to protect individuals from harm. This balance is delicate and requires the judiciary to exercise their discretion with great care and responsibility. The Act outlines specific grounds for granting name suppression, emphasizing the need to prevent undue hardship or prejudice, protect the fairness of proceedings, and safeguard the interests of vulnerable individuals. These grounds include the risk of causing extreme distress or danger to the safety of a person, the potential to compromise the integrity of the judicial process, and the necessity to protect the privacy of victims, especially in sensitive cases such as those involving minors or sexual offenses. It recognizes that in certain cases, the potential harm caused by publicity can outweigh the public's right to know. The law seeks to strike a balance between transparency and protection, ensuring that the judicial process remains fair and just for all parties involved. By allowing for name suppression, the Act acknowledges the profound impact that media coverage can have on individuals' lives and aims to mitigate any negative consequences that may arise from such exposure. The circumstances under which name suppression is granted are varied, reflecting the diverse nature of cases that come before the courts. One common scenario involves cases of a sensitive nature, particularly those involving sexual offences. Protecting the identity of victims is crucial to encourage reporting and prevent further trauma. Another common situation is the protection of minors. Children and young people caught up in the justice system are particularly vulnerable, and their identities are often suppressed to shield them from the stigma and potential consequences of public exposure. The Judge's Balancing Act, factors influencing name suppression. The decision to grant name suppression rests solely with the judge presiding over the case. It's a decision not taken lightly, requiring careful consideration of a range of factors. One crucial factor is the potential for extreme hardship to the individual seeking suppression. This could include threats to their safety, loss of employment, or social ostracization. Another key consideration is the right to a fair trial. If publicity surrounding a case is deemed to prejudice a jury, making it impossible for the defendant to receive an impartial hearing, name suppression may be granted. Challenging a name suppression decision, the appeals process. The justice system is built on checks and balances. Just as an individual can apply for name suppression, the decision to refuse such an order can be challenged. This is done through the appeals process. An appeal allows a higher court to review the original decision, considering whether the judge erred in their assessment of the relevant factors. It provides a vital safeguard, ensuring that decisions regarding name suppression are subject to scrutiny and accountability. The global reach of information, international implications. In today's interconnected world, information travels at lightning speed, transcending geographical boundaries. This poses a unique challenge for name suppression orders, which are inherently limited in their reach. While a New Zealand court can prohibit publication within its jurisdiction, it has no control over international media outlets. This means that information suppressed in New Zealand may still be accessible to a global audience online. It highlights the limitations of national legal frameworks in the face of the borderless nature of the internet and the challenges of enforcing legal orders in the digital age. Beyond name suppression, courtroom closures and reporting restrictions. In some cases, protecting the integrity of proceedings requires measures that go beyond name suppression. Courts have the power to order a courtroom to be cleared, excluding the public and media from observing the proceedings. This is usually done in cases involving sensitive evidence, vulnerable witnesses, or when there's a risk of disruption or harm. Similarly, reporting restrictions can be imposed, limiting what information journalists can publish about a case. These restrictions aim to balance open justice with the need to protect the fairness of the trial and the safety of those involved. Conclusion: balancing privacy and the public's right to know. Name suppression is a complex and often controversial issue. It involves withholding the identity of individuals involved in legal proceedings from the public. This practice is not just about protecting the accused, but also witnesses, victims, and even jurors in certain cases. The reasons for name suppression can vary widely, from protecting vulnerable individuals to ensuring a fair trial. It represents a delicate balancing act between competing interests, the individual's right to privacy and a fair trial, versus the public's right to know and the principles of open justice. The media plays a crucial role in this dynamic, often pushing for transparency and accountability, while the courts must weigh these demands against potential harm to those involved. While transparency is a cornerstone of a democratic society, there are times when the potential harm caused by publicity necessitates a degree of secrecy. For instance, in cases involving minors or sensitive personal information, the exposure could lead to undue distress or even endangerment. Thus, the courts must tread carefully, balancing the scales of justice with the need for discretion. The legal framework surrounding name suppression, as embodied in Section 200 of the Criminal Procedure Act 2011, provides a roadmap for navigating this complex terrain. This legislation outlines the criteria and procedures for granting name suppression, ensuring that decisions are made based on consistent and fair principles. It emphasizes a case-by-case approach, with judges carefully weighing the relevant factors before making a decision. Factors such as the nature of the crime, the potential impact on the individuals involved, and the broader public interest are all considered. This nuanced approach ensures that each case is treated with the attention and sensitivity it deserves. Ultimately, the goal is to ensure that justice is served while safeguarding the rights and well-being of all those involved. By maintaining this balance, the legal system strives to uphold the principles of fairness and transparency, ensuring that the public remains informed without compromising the integrity of the judicial process.